Hey guys, welcome back to the channel where I cover missing persons, unsolved cases, crime news, and more. Well, I got a few docs to go through, but the Daily Mail, which folks may or may not take seriously, it's up to you. However, her attorney, Miss Alexee Trevizo, spoke with the Daily Mail exclusively. And it's probably going to piss you off, because it's pissing me off already. Of course, we already know what he's been saying, but this is a little more in depth than what he's said to, like Vinny on Court TV and what have you. Alexee Trevizo's lawyer claims hospital staff killed her baby by giving her morphine while she was unknowingly in labor. I call bullcrap. And from what you guys have had to say in the comments, some of you guys were given morphine, some of you may not. It seems like it's, it's done in some facilities, not in others. So it's definitely not something that's going to kill her child. And morphine did not put baby Alex in a trash bag and tie it and put it underneath another trash bag in paper towels. Morphine didn't do that. Alexee did that. So just going to sift through this particular article, and of course I will put the link to it in the information of the video so you can check it out for yourself. But in a nutshell, they're saying that of course that she's innocent according to her attorney, which of course I just did a video on him, and while I highly respect his training and his ability to defend such people, put it that way, I completely disagree with everything pretty much that he has to say. We all know that she's charged with murdering her newborn back in January, and that her lawyer is claiming it's the hospital's fault. So there's some quotes down here, so I'm going to go through that a bit here. And of course they got all the body cams, and there's one of her mug shots, and a couple folks have asked why she's got more than one. I'm not really sure of that. Of course I haven't really overlooked into that either. But basically, there's a lot of docs that we're going to be going through. Her team, of course, is fighting to have the charges dismissed, which is ludicrous and insane. They're stating that the baby boy was dead before she delivered it, and it was stillborn. That's basically the bottom line of what her defense is, and that it's all the hospital's fault according to Gary Mitchell, her lawyer, and that if they wouldn't have given her morphine and what have you, that this baby would have been alive and well. So we've got, they obtained the legal filings, and Mitchell, of course, was stating that hospital staff and city workers violated HIPAA laws by sharing her medical records and discussing the case. Now, I don't believe that they've really gone against HIPAA completely. I don't know who released every single portion of all her records, because I know in the body cam that we went through in the last video, the head nurse there, the head charge nurse, was very careful in particular to make sure that nothing was released to law enforcement without a warrant. So as far as what's been released publicly, I think we're going to find out as the case progresses. But of course, he's claiming that by the time the case goes to trial, it's going to be clear that she didn't strangle the infant. Well, maybe she didn't strangle baby Alex, but she put him in a trash bag, okay? And he's saying this is not a murder case, and that the baby, again, was stillborn. He's claiming that because they gave Alexee a cocktail of drugs that are inappropriate for pregnant women, that it caused the death of baby Alex. He said this certainly was the primary cause of death of the baby. Guess what does cause major breathing issues in fetuses? Morphine, he said. Yeah, I did look that up, and morphine can be an issue for pregnant women in the end stages. That said, again, I have to argue, Mr. Gary Mitchell, that morphine did not put that baby in a trash bag, tie it, and hide it. Mitchell is stating that the toxicology report shows the baby had a 0.19 nanograms of morphine in his system when he was born, and he also tested positive for COVID-19, influenza A and B, and SARS. I'm a little unsure about all that situation, but again, I don't believe that particularly matters. I could be wrong, and folks that are in the know can definitely correct me in the comments on that one. He maintains that Alexee did not know she was pregnant, despite gaining weight and developing a bump that was clearly visible through her cheerleading clothes. He said, women will say to me she gained 10 or 15 pounds, so she must have known. But she was on her period when she went to the hospital, he's saying. And scientifically, 1 in 2,500 women do not know they are pregnant when they deliver, especially teenagers. Okay, let's just say, let's put it out there that she had no idea. Let's just say that. As soon as she went to the bathroom, of course, I don't believe it, she didn't know. But let's just say she didn't, just to, get on that particular angle. She goes to the bathroom thinking she's got to take a big poop, and all of a sudden this baby comes out, and she's like, holy hell. What would a normal, rational person do? They would ask for help. Okay? And again, that's where when they kept coming to the door, asking if she was okay, she could have yelled out. She could have pushed the buttons in there for help. She could have pulled the emergency help. There's multiple ways that she could have gotten help. She was in a hospital equipped to help her. And I run with a group that we run by a local hospital every weekend, and we go in there to use their facilities in the emergency room area. And I went in there and I took a photo inside the bathroom, and there is such a switch. You've got buttons, 2 buttons, and a pull. And I asked the guy at the desk out there, I said, so if someone were to come in here, push one of those or pull that emergency pull, how quickly would someone be in there? He'd say, like, fast, within a couple minutes, not even. So, yeah, she was in that bathroom for 19 minutes, supposedly giving birth and hiding it. And in all that time, she never once asked for help. He goes on to state that she went to McDonald's every day with her boyfriend. Yeah, we know, Devin. She thinks that putting on the weight is normal. She was taking birth control and had a period. He's claiming also that she didn't feel kicking and she didn't feel sick. I don't know. I mean, about the kicking part, I don't know, guys. What do you think? I'll be honest. I have never given birth. I've never had a child at this point. So, do you, that those folks, those ladies who have been pregnant, do you think that being the fact that she was basically full term, do you think that she didn't feel any kicking or moving of her child? From what I understand from people I've asked, they don't believe that she wouldn't. And why would she think she was pregnant? Well, because people did ask her. And there's that whole part of where she told classmates that she was going to name her child Alex. Okay. Answer that one for me, Mr. Mitchell. And he goes on to say that the staff unintentionally continued giving Alexee drugs that would harm the baby's breathing for too long. And he states on January 26th, she goes to the hospital and arrives at 12:03 a.m. By 12:05 a.m., she's admitted. At 12:18 a.m., they started giving her muscle relaxants. Then at 12:28 a.m., they gave her morphine, and they also gave her more pain meds. And that continues for 111 minutes. Okay? Then they give her ketorolac, and I know I'm saying that incorrectly. Like I stated, I'm not a medical professional. I don't even play one on TV. Which you are not meant to get pregnant women and ondansetron for nausea. Okay. And they gave her cyclobenzene, a muscle relaxer, acetaminophen, and morphine, which you're definitely not meant to give during labor. I would say that that's a little bit pushing it, Mr. Mitchell, because, like I said, from the few videos that we've done here, I'm hearing a mixed bag of responses on the morphine situation. So I don't think it's completely unheard of to use morphine. I don't believe so. Does every hospital facility use it? No, but I don't believe for 1 second that that's what killed baby Alex. And then he goes on to state that at 12:28 a.m. she was given morphine and blood tests, and then by 12:51 a.m. they knew she was pregnant. And then it was at 1:39 a.m. that she goes to the bathroom. They had to remove the IV so she can go to the bathroom. And of course, prosecutors say Alexee knew she was pregnant, but was desperate to hide it from everyone. After giving birth in the bathroom, she placed the baby in the trash can and covered him in a bin liner. The infant was discovered by a hospital cleaner who was left traumatized by what she found. I'm still horrified for that housekeeper. I truly, truly am. So, but the bottom line is, he's standing by this, and I'm sure Rosa and Alexee love this attorney. And there he is. There's Mr. Gary Mitchell. But I'm sure they love him because he's buying their party line, and he's going for it, and that's what they want. They needed an attorney who's going to do that, and I'm pretty sure that Rosa is footing the bill for her daughter's murdering of her grandson. Or maybe it's the stepdad, or maybe dad. I don't know, but he's not a public defender. He's a pretty high-cost attorney, and he's been doing this for, as we heard in the last video, if you didn't check it out, I did a little bit of a deep dive on him, and he's definitely, he's not a cheap attorney. He's been around, and he's well known in the New Mexico area. He's hardcore, and he fights for his clients. So, like I said, whether we like him or not, he's gonna fight for this one right on the screen here, whom I fully believe guilty of murder. And I this whole crap with the morphine and the fact that killed the baby, nah, come on, Gary, that didn't kill the baby. Again, like I said before, morphine didn't put baby Alex in the trash bag. Morphine didn't tie the bag. Morphine didn't put another bag on top of the bag. And you know what also morphine didn't do? Morphine didn't put a bunch of paper towels on it. And the bottom line is, that was Alexee. And he's going to probably go on to say, well, it was all the drugs. She was so out of it. She wasn't out of it. She was totally fine. She walked out of there like nothing was going on. Oh, I delivered a baby. Walk out of the bathroom, throw my paper towel in the trash. Hey, maybe they'll let me go soon. I can go home. She was hoping no one would discover the horror that was in that trash can. But they did. And she can't take it back. And of course, she wants to go to college now. She wants to go to college. Alex is never going to be able to go to college, Alexee. And you know what? Alex is not going to know half of anything that you've been through. All you had to do was ask for help. It was that easy. It was that easy. Then we have some more documents. They seem to keep dropping. I don't know about daily, but they're dropping pretty regularly here. This one was dropped on the 7th. And this one is the state of New Mexico's response to exercise of privilege, motion to suppress, motion for protection order, and Pena versus Espinoza, procedure determination. Now, I'll try to zoom in on these as much as I can here. So again, this was filed on 8/7 at 3:26 p.m., State of Mexico versus Alexee Trevizo. Comes now the State of New Mexico and through District Attorney Diana Luce and hereby requests the court deny defendant's above title motion to exercise privilege, suppress evidence, and for a Pena versus Espinoza procedure determination, and states the following in support thereof. Okay, we got statement of facts. Number 1, on January 26th of 2023, defendant was admitted to Artesia General Hospital, HEH, shortly before midnight, complaining of lower back pain. Number 2, while being evaluated, the defendant entered a patient restroom alone and locked the door behind her. Number 3, the defendant remained in the bathroom for an extended period of time and refused to open the door for staff who became increasingly concerned for her well-being. Now remember, they were concerned that she was hurting herself. They had no idea of how bad it really could get in there. Number 4, hospital staff were forced to get a key from security to enter the restroom. Number 5, when nursing staff entered the restroom, they were confronted by a large amount of blood. So basically, as they were about to enter that bathroom, she came out. So that's a little bit missing somewhere on there. Number 6, concerned by the large amount of blood, nursing staff checked both the toilet and trash can for evidence of a pregnancy or miscarriage. The toilet and top layer of the trash can appeared to be empty upon initial inspection. So it wasn't just as if she put it in the trash can. From glancing, and I believe they have photos of all this, from what I understand, and I hope to God they do. From initial appearances, besides the bathroom was a bloody mess, they didn't see a baby in the toilet, they didn't see a baby on the floor, they didn't see a baby in the trash can. Unfortunately, they didn't pick it up and go through the trash can, because who would have thought that, again, that somebody would not only deliver a baby in the bathroom and not tell them, but deliver a baby, put it in a bag, tie the bag, put another bag on top of it, put a bunch of paper towels so you couldn't tell that anything was in there. Very well hidden. She was a very sneaky one, this Alexee. Number 7, when a custodian cleaned the bathroom, they noted the trash can was inordinately heavy. That's when she realized it, and sadly, it took some time before that trash can was actually handled. As housekeeping pulled the trash can liner, hospital staff found a newborn in the trash can. Number 8, nurses began to administer life-saving measures on the newborn baby boy, but he was already cold and blue. This particular statement bothers me just a bit, because from what I understand, see, that's this one here, like I said, this one does confuse me, because I believe this one is wrong, because we were told that initially that the nursing staff and the doctor did not administer life-sustaining measures on baby Alex. Because he was blue, he had no life at all. So, number 8 does bother me slightly, especially considering that this is a court-filed document on behalf of the state. Number 9, emergency department physician Heather Vacus declared the newborn boy dead at 2:28 a.m. on January 27th, 2023. Number 10, given that a potential homicide involving the abandonment and abuse of a child had occurred on AGH premises, the hospital contacted law enforcement. Number 11, the attending physician advised the defendant of the discovery of the newborn and that life-saving measures were unsuccessful. Yeah. This particular document's bothered me a little bit, guys. Number 12, law enforcement officers were present in the treatment room when the defendant was informed of the discovery but asked no questions of the defendant themselves. Number 13, defendant, upon learning her baby had been discovered dead, concealed underneath an extra trash bag, the defendant exclaimed, "I'm sorry, it came out of me. I didn't know what to do." Number 14, medical staff advised the defendant of the next steps in the treatment process, and law enforcement officers advised the defendant that she was not under arrest but being detained for investigative purposes. Number 15. The defendant's mother began asking her questions related to her delivery and disposal of the newborn boy, and officers asked her not to speak to her daughter about the circumstances until detectives were able to initiate their investigation. Number 16, the defendant was transported to another facility, which was Lovelace. I thought it was Loveless, but I guess it's Lovelace Hospital in Roswell, New Mexico, for further medical care. 17, interviews were conducted with the medical staff, who were mandated reporters, in reference to the criminal investigation regarding a homicide that occurred on AGH premises. So those are the facts. And again, I am a little concerned that this is starting to be a little bit off from what we initially learned. But let me know what you guys think about that as well. Law and argument. The defendant's motion to suppress based on alleged violations of the Health Insurance Portability and Accountability Act of 1996, otherwise known as HIPAA, medical records privacy provided by NMSA 14-6-1 in New Mexico Rule of Evidence 11-504 should be denied, as HIPAA allows disclosure of information to law enforcement under the circumstances of this case. Additionally, HIPAA violations, even if one had occurred, do not mandate suppression of evidence. Likewise, New Mexico Rule of Evidence 11-504 confers no physician-patient privilege with respect to communications knowingly made in the presence of third parties. HIPAA does not preclude medical providers from disclosing information to law enforcement regarding a crime committed on premises. The defendant argues that all medical records disclosed in violation of the privilege and or HIPAA be suppressed. HIPAA is the primary federal law which was passed to ensure an individual's right to privacy over medical records. United States v. Zamora 408F SUP supplemental, 2D 295 298 SD Texas 2006. It governs the confidentiality of medical records and regulates how and under what circumstances covered entities may use or disclose protected health information about an individual. ID, the term covered entities is defined to include healthcare plans, healthcare clearinghouses, and healthcare providers. 45 CFR 160.102, 164.104. Protected health information includes all individually identifiable health information maintained or transmitted in any form, as well as any oral statement, made about medical treatment or conditions. 45 CFR 160.103. Generally, HIPAA prohibits the use and disclosure of an individual's protected health information unless the individual has authorized use and disclosure. HIPAA provides, however, that a covered entity may use or disclose protected health information without the written authorization of the individual or the opportunity for the individual to agree or object in certain limited circumstances. One of those exceptions is where a law enforcement official seeks protected health information for a law enforcement purpose. And I'm going to skip going through the cases here. Most notably, a covered entity may disclose to a law enforcement official protected health information that the covered entity believes in good faith constitutes evidence of criminal conduct that occurred on the premises of the covered entity. In the present case, a homicide involving the abuse and abandonment of a newborn occurred on the premises of AGH. Providers were entitled to disclose protected health information that constituted evidence of that crime on the premises of the covered entity. Artesia Police Department were called to the Artesia General Hospital for after hospital staff found a deceased newborn in the trash can in a bathroom. Upon arrival, they spoke with the charge nurse and the attending physician, who stated to officers that a pregnancy test was done on the patient defendant, and that the defendant was in the bathroom for a while, and when the defendant came out of the bathroom, there was a lot of blood everywhere. So more exams were done on the defendant, and of course they're referencing the body cams, and I'm a little also concerned that there seems to be some grammar issues here. After the defendant was notified that the newborn was found deceased. Law enforcement began to gather the names of all the Artesia General Hospital staff that had some involvement or contact with the defendant and therefore may have had relevant information to the incipient criminal investigation. L. Lewis described the condition of the bathroom, described how the trash can liners were placed in the trash can, and described that trash can liner felt heavy when she was going to change the liner in the trash can. She also described what she did when she found the newborn, referencing the body cam again. And at no time in her initial interview with the Artesia Police Department on January 27, 2023, or her follow-up interview in April of 2023, did she violate HIPAA by disclosing any protected health information as set forth in 45 CFR 165.512. Additionally, custodians are not covered by HIPAA. That's a good point as well. The emergency room tech, CNA, Lori informed officers that she checked on the patient who had been in the bathroom for an extended period of time and called the hospital housekeeping staff when she saw that the bathroom needed to be cleaned up. She informed officers that the defendant had a positive pregnancy test. Lori told the officers that when she found the newborn, she immediately took him to Trauma 2, informed her supervisor, and called the police. She stated to the officers she delivered the baby and threw it in the trash. Those were her personal observations, not information learned from treating the defendant. H. Halliday was the charge nurse on the night of the incident. He spoke to officers several times throughout the evening as the events were happening and as the hospital was preparing the defendant to be transferred to another hospital with a higher level of care. During his initial interview, he told officers that the defendant was admitted to the hospital with lower back pain and that a battery of tests was conducted on the defendant to include a pregnancy test, an ultrasound, and a vaginal exam. After the discovery of the newborn, he described what he saw in the trash can and described that he ripped open the liner that the newborn was in. He described to the officers the condition of the newborn and that there were no signs of life. Referencing again the body cams. The information that the charge nurse gave to officers during this initial interview was all the information that could be disclosed to law enforcement. Yeah, remember, he said again that he couldn't give them any more information until they had the warrants. So for that particular evening, they were very careful. He provided the defendant's chief complaint, date and time of death of the newborn, and the tests that were conducted on the defendant. This information was all relevant to the investigation of the crime that occurred on AGH premises. When the officers were gathering information about the defendant, they asked for a sheet from one of the hospital staff. Out of an abundance of caution, the charge nurse told this employee to not give the officer the defendant's sheet, just to provide them with her name so as not to violate HIPAA, since they had not yet received a search warrant. There we go. So that definitely is covered. By telling the officers that they can only be provided with the basic demographic information of the defendant so as not to violate HIPAA, clearly indicates that the charge nurse was acting with due regard for his patient's private medical information, even though HIPAA disclosure exemptions would have permitted more comprehensive disclosure during a police investigation into a crime that occurred on AGH premises. So yeah, they were very careful that night. That charge nurse was right on it. On April 20th, 2023, as the Artesia Police Department was still investigating the events of January 27th, 2023, Dr. Vasquez was interviewed. She described to detectives the basic labs that were run on the defendant, that when they received a positive pregnancy test from the urine test, another test was run to determine more information about the pregnancy. What is known as quantitative HCG test. She discussed the type of injury that the defendant had after coming out of the bathroom, and what she did when she learned the news that the other staff had found a newborn baby in the trash can liner. The information that Dr. Vasquez gave to officers also falls under what can be disclosed to law enforcement without a search under 45 CFR 164.512. Detectives from the Artesia Police Department obtained a search warrant on May 10th, 2023, which was signed by, oh dear, these typos, guys, come on, the Judge Foster of the Artesia Magistrate Court. Included for the application for the search warrant was an affidavit of events that occurred on January 26th to 27th, 2023 at the Artesia General Hospital, and the warrant is for the defendant's DNA and other biological samples. No DNA, tissues, blood, urine, or other biological samples of the defendant were obtained from the defendant by the Artesia Police Department on the night of January 26th through 27th, 2023. Thus, there is no violation of the HIPAA. So yeah, nothing was happening that night. They made sure the hospital was covering their butts. Okay? CYA, cover your ass. They were totally doing that. Even assuming Argenino, and I'm saying that completely wrong, sorry guys, that there had been a violation of HIPAA, the remedy would not be suppression of evidence obtained as a result. HIPAA itself does not provide that medical information so be obtained must be suppressed. The court is unaware of any authority which compels the suppression of records obtained in violation of HIPAA at trial. Therefore, the alleged HIPAA violations would not warrant suppression of evidence at trial, even had they occurred. So they're saying that nothing was violated, and I don't believe it was at all. I haven't believed it was. But man, these typos, guys, and there's another one right here. These typos are bad news. Come on. Come on, guys. Ugh. Defendant waived any privilege conferred on her by New Mexico Rule of Evidence 11-504. The defendant's argument that her statements to medical providers are privileged pursuant to, I'm not going to read all these numbers anymore for you guys, should fail because the defendant waived any privilege conferred upon her by this rule of evidence when she spoke with physicians in the presence of police officers. The New Mexico Court of Appeals recently had the opportunity to consider this very issue in State versus Lucero, and in that case, the Court of Appeals addressed the question of under what circumstances does the presence of a third party able to overhear a communication between a physician and a patient negate the privilege? In Lucero, the defendant was involved in a motor vehicle collision. Law enforcement arrived on scene and extradited the defendant from their burning vehicle. When the ambulance arrived, the defendant received emergency medical care from EMS in the ambulance, and law enforcement entered the ambulance from the side door. The paramedics asked the defendant if she had anything to drink, and the defendant stated 3 Crown and Cokes. Based on this information, the law enforcement officer asked follow-up questions to the defendant about what she had to drink, and she began to cry and did not answer, but did ask the deputy if he was recording, to which a deputy answered in the affirmative. Yeah. Never talk to a cop or a police officer if you are not prepared to have it recorded. Period. The Court of Appeals decided that the issue of whether the defendant waived physician-patient privilege turned on whether the defendant actually knew the law enforcement officer was present when they made the incriminating statements to EMS. State versus Lucero, lists the case number there, and the court noted that defined a confidential communication. A communication is confidential if not intended to be disclosed to third persons other than those present to further the interest of the patient in the consultation, examination, or interview, or persons reasonably necessary for the transmission of the communication, or persons who are participating in the diagnosis and treatment under the direction of the physician or psychotherapist, including members of the patient's family. In determining whether the patient intended the communication to be privileged, the Court of Appeals ruled that if a patient is told their communications with a doctor or therapist will be disclosed to a third party, and the patient voluntarily proceeds with the consultation with that knowledge, they will be considered to have consented to or voluntarily acquiesced in the disclosure. The patient having voluntarily consented to or acquiesced in the disclosure by their conduct cannot claim the privilege. So the bottom line is, if they were told that this could be revealed to third parties, you can't later on go, whoa, Now you can't use that. Wrong. The Court of Appeals, Lucero analysis leads to the conclusion that the defendant waived privilege when she made statements to her physician, knowing that law enforcement officers were present in the room. The defendant was in a room with officers from the Artesia Police Department, the attending physician, the charge nurse, and the defendant's mother, at which time the attending physician told the defendant about the newborn baby and what the next steps in the medical treatment would be. After learning of the news that the newborn was deceased, the defendant made the comment, "I'm sorry, it came out of me. I didn't know what to do." So she said this right in front of the nurses, the doctor, and the police. It was clear to the defendant that law enforcement officers were in the room. Yeah, it's not as if she couldn't see them standing right in front of her. The defendant's own Miranda arguments demonstrate that she knew law enforcement was present. Thus, under New Mexico law, the defendant waived whatever physician-patient privilege that had conferred upon her. Even assuming, arguendo, that the defendant did not know law enforcement was present, her statement cannot be considered a statement for the purpose of diagnosis or treatment. The defendant's apology and statement did not concern the course of her own treatment or the deceased newborns. Therefore, this evidence provides no privilege against the admission of the defendant's statement at trial. So basically, she knew the cops were right there. And so this was not protected physician-patient privileged information. Period. Bottom line. So let me kind of just sift through here. And they go on to explain also that the defendant's Miranda rights were not violated because she was never in custody or nor interrogated. So remember, she had asked, Mama asked too. Mama Rose is like, is she under arrest? She was never under arrest. She wasn't free to go. But remember, they were concerned for her well-being. So she was never, her Miranda rights were never a problem for her. All right, and it looks like in conclusion, they're stating that therefore the state of New Mexico hereby prays that the Honorable Court deny the defense's motion to suppress based on alleged HIPAA violations, claims of privilege, or other unspecified misconduct. Likewise, the defendant has not met their burden for the court to hold a Pena versus Espinoza procedure determination. Finally, the state takes no position on the issuance of a proactive order related to the defendant's medical records. So the state is saying that nope, hospital never violated her HIPAA rights, her patient privilege, none of that was violated, so this can't be thrown out. That's the bottom line of all that. And it looks like they're going through now the state of New Mexico's response to the defendant's motion to reconsider her conditions of release. Let's see. Comes now the state of New Mexico, and through the district attorney, Diana Lucy, has hereby request the court deny defendant's above titled motion. In support of its request, the state submits the following. Facts. The state incorporates by reference the arguments, facts, and findings of both the pretrial detention hearing and preliminary hearing held in this matter. As the court is aware, the defendant is charged with first-degree murder and tampering with evidence for disposing of her newborn baby boy in the trash can in a restroom of Artesia General Hospital after she concealed the newborn in a trash can lining. Legal argument. Under Rule 5-401C and MRA, the court should consider the nature and circumstances of the charged offense, including whether the offense is a crime of violence, the weight of the evidence against the defendant, the history and characteristics of the defendant, the nature and seriousness of the danger to any persons or the community that would be posed by the defendant in the absence of conditions of release designed to prevent such harm. The defendant's motion to reconsider her conditions of release focuses entirely on her desire to continue a personal relationship with her boyfriend, whom she is currently forbidden from having a dating or intimate relationship with. Yeah, you're not allowed to see him, hun. Following the pretrial detention hearing, the Honorable Judge David E. Finger wisely ordered the defendant not have any personal contact with any person who is or could be defined as a continued personal relationship. This prohibition restricts the defendant from having a dating or intimate relationship. So I don't know if they can do that, but I guess they're trying to prevent her not only being with him, but they really don't want her dating right now. I'm a little unsure if they could go that far. The last time the defendant engaged in such a relationship, the result was her disposing of a newborn baby in a hospital trash can, where the baby ultimately died. This prohibition is designed specifically to mitigate the risk of defendant reoffending in such an egregious fashion while she is pending trial for first-degree murder. Well, the bottom line is she's free on bond right now. I mean, she's fortunate as heck. Because, they don't want her to, they don't want her to go, hey, I'm going to have some more relations and have another kid. Yeah, we don't want that to happen, Alexee. Despite the counseling the defendant claims to have engaged with, she nevertheless sees no harm in attending college with a man her counsel describes as her boyfriend. The fact that the defendant has a boyfriend at all is an apparent violation of her current conditions of release. The defendant seeks permission to continue this relationship with her boyfriend, attend the same college, spend time together in class and on campus, and commute to and from school. The defendant's apparent disregard for her current conditions of release, evidenced by her continuing a relationship with her boyfriend, illustrates why the condition of release prohibiting her from engaging in a dating or intimate relationship should remain in place. I agree. The defendant's motion should be denied, and her apparent violation of her current conditions of release should be addressed in the hearing requested by her counsel. The defendant's motion should be denied using the factors articulated in Rule 5-401C and DNMRA. The defendant's admissions, video evidence, and fact witness testimony demonstrate that the defendant's conditions of release should not be modified to less restrictive as there is strong evidence against her. The charges are extremely violent and serious and include the use of wanton evidence against a helpless newborn baby and the calculated concealment of her murder of that newborn. Wherefore, the state respectfully requests the court deny the defendant's motion to reconsider conditions of release, maintain the current conditions of release, and address the apparent violation of her current conditions of release. That one is well written. I don't know what was up with the other one. But I completely agree with the state on this. She wants to be comfortable. She doesn't want to be restricted. Well, Alexee, honey, you're already free. You're on bond bail. And now you want to go back with your honey and go to college like nothing happened. And that's just not the way it is. Yeah, she wants to go back to her life before she did what she did in January. It seems to me that she believes baby Alex, she's not saying this. Now, let me make that clear. In my opinion, she's basically saying that he meant nothing to her, and the baby Alex has ruined her life, and now I want to go off to college and have, my normal life. I'm a young 19-year-old. I just want to enjoy my life. Well, that could have been done. You had many chances. I have zero compassion, zero sympathy for this person right here. And I actually like that she looks like she was crying in the first picture on the left. That was after she was arrested at home. Remember how they went to her home? And they said, her mom was like, I have to see the warrant. You have no right to come in my house. Da 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 da. And the officers were so accommodating. They were amazing. Their patience was above and beyond. And they finally got her. And they took her in custody. And they took care of everything. And of course, I'm sure Mama bailed her out soon thereafter. But she is lucky. She is lucky that she is able to be free at this moment. I just don't know. To me, it's insane that she's expecting life to go on like normal. I'm sorry, Alexee. Life is not going to be normal for you. You killed your baby, and you got to answer for that. And you know what? You can go to school while you're in jail. And if you really want to go to college, well, maybe you could take classes at home. Online school. But I really hope that they do deny it. I hope that they're going to deny the motions to let her see her boyfriend and to let her go to college. She shouldn't have any of those luxuries right now. She shouldn't. But that's what I'm going to go over for this particular one. There's so much more coming through on this case, guys. I'm trying to keep them not crazy long so that we can kind of go over everything. But let me know what you think of all this stuff. It does still bother me a bit, some of the indiscrepancies there. And that first response from the state and how badly written it was. Man, they just need an editor so bad. But let me know what you think. And with that said and done, I hope you have a great rest of the day. And most of all, stay safe.